All right. Hi, everyone. Welcome to another episode of the Mindgasms podcast. Going to do another episode with Tim Keefe today about philosophy. We're going to talk about postmodern law based on another one of those essays from the Cambridge Companion to Postmodernism that we've been going through. So it'll be interesting to learn about postmodern law, especially since when we were originally talking about which sections we would cover in this book. Postmodern law, I think, was the one of the ones, Tim, that you said not to go over. So that's one of the ones that that I actually haven't read or taken notes on. So this will be like a real-time learning experience for me on this one.
Yeah, originally I thought we could skip it, but when we did the ethics one, I thought, well, if you're going to talk about ethics, then you should probably talk about law and justice because the two are so closely intertwined.
Yeah.
And in fact, in this essay, the author Kostas Douzinas, I think that's how you pronounce her name, also mentions Levinas, who we'd mentioned the last time with the ethics.
Mm-hmm.
Okay, so with that out of the way, so we are at the at the last essay in the Cambridge Companion to Postmodernism that we have chosen to do. It is technically not the last essay. The last essay is the one on postmodern theology, but you and I talked before, and I think it's best if we go ahead and shelve that until a later time, perhaps later in the summer when Shane Kennedy said that he would come back from his vacation and maybe he would be ready to delve into postmodern theology.
Yeah, in
So
at
we
least
could
a few weeks.
yeah, we could use that essay, and that could be a nice segue into the other postmodern volume, the Cambridge Companion to Postmodern Theology,
Yeah, that'll
which
be interesting.
is an entirely new volume.
Yeah,
Who knows? We can get Hayden involved in that too, since he does the Pragmatic Christian podcast.
yeah, that'd be interesting too.
Okay, but
And
that's for another time.
yeah,
So what we have to go through is the essay. This is chapter 10 for those playing the home game. It's on page 196. Costas Douzinas, Law and Justice in Postmodernity. Okay, so in our last episode, we covered ethics. And yes, there is such a thing called postmodern ethics. And what does that look like? Well, we've already covered a lot of that, but Emmanuel Levinas featured prominently in that. Levinas is a vast fertile field to get into. You could spend an entire career going through his works as well. But one of the themes you pull from him is that he was a contemporary of Heidegger, but he was also critical of Heidegger. So Heidegger's main thing is being with a capital B. That's all I'm going to say about that. Levinas says, no, it's not being, it's ethics, morality, actually, because you're dealing with the other, which in this essay, we're going to get to it shortly, is alterity. There's a term to designate the other, alterity.
so
Okay.
what does that mean exactly?
So it's a philosophical term to describe otherness.
Okay.
Okay, so when we were discussing the ethics with Levinas, it is about the other, the capital O other. So something that is not me, somebody that is not me.
Okay.
Radically other is that there's no shared experience or shared universe of discourse, shared language, whatever it could be, that I and the other share. Okay, that's a radical other, something that's indescribable, inscrutable to me as the subject. Where we're working with a subject-object distinction here. However, there still is otherness with the people that we encounter in our lives. You to me is the other. I to you is the other, even though we might share more um, common characteristics than, say, a radical other does.
Okay.
Okay? But with the ethics is, I am faced with the other. This is the subject. I am faced with the other, and so I must deal with the other in such a way to not rely on a third term, as Levinas said. So that's his one criticism of Heidegger. Heidegger is relying on being as a third term, just like thought is a third term. Okay, and so we had discussed this like in experiencing an object, not as another subject, but as an object, without categorization, without descriptions. That is the immediate experience that I have of that object. As soon as I introduce thought or categorization or whatever it is, I'm introducing a third term that is putting the object, the other, at a distance from me.
Hmm.
Okay.
Okay. So, hmm. I think I require a little bit more clarification there.
Okay.
So, like
Well,
when you add the third term, it puts a distance between you and the object because you're adding new information or because you're categorizing it or what?
because it's categorization.
Oh,
So
okay.
if
Okay.
you're looking at an object, the trusted object of the apple. I see the apple on my desk. I describe it as such as an apple. Already I've introduced the thought of the categorization that what I'm looking at is an apple. I've already categorized it.
Okay.
Prior to that, when I was experiencing it, it was a more immediate type of experience. I know that there is an object before me, but I haven't categorized it yet.
Okay.
Okay. So
Okay.
that's it in a nutshell. But Duzinas later on in the essay will cover Levinas, um, some of the same things we'd encountered in the ethics essay.
Okay.
Okay.
Mm-hmm.
So let's get
Yeah, that
cracking.
makes sense. All right.
So, as I said, I originally wanted to set this aside, but I thought, well, yeah, going over law and justice is a good one to look at because if you're going to, for lack of a better term, subvert common ethical theory, law certainly is based on a form of ethics, as is
Yeah.
jurisprudence, very closely related. So if you're going to introduce postmodernity or discuss the postmodern in ethics, then you should do so with law and justice. Okay.
Yeah.
So in the beginning of the essay, the first paragraph, Duzinas says, quote, postmodernity has undermined our belief in the universality of law or in the ability of an ideal equity to ground its operations. What is the meaning of justice in a world of cognitive and moral uncertainties? Fair point. The moral deficit of law goes hand in hand with the crisis of legal form. This concerns the complementary process of proliferating juridification, I like that term, of social and private spaces, and of privatization or deregulation of hitherto public areas of concern and provision. This is a common postmodern complaint. This double move has turned the traditional divide and boundary between public and private arenas of action and regulation, upon which much of modern law rests, into an elastic line of passage, communication, and osmosis. Administrative law, to take an obvious case, keeps extending its scope to an increasing number of previously domestic areas. This regulatory colonization does not seem to represent or pursue any inherent logic, overarching policy direction, or coherent value system. Policy considerations differ between family law and planning, or between criminal justice and the regulation of official secrecy, privacy, and data protection. Even worse, contradictory policies appear to motivate regulatory practices in each sphere. The fragmented legal form keeps colonizing the social, a development that goes hand in hand with the privatization of public services and deregulation. Okay, so in a nutshell, what he or she is saying here is that previously there was this distinction between public and private.
Right.
Okay, so with the public, we're dealing with more juridical, law-based type of things because this is the public. Not so in the private area. However, there's been an ever increasing encroachment of juridification, of the intrusion of the juridical justice and the like into the private area. But the problem with this is that this juridification, this introduction, is fragmented. It's not consistent. So what was previously prior, and this is where the privatization and the deregulation comes in, this is applying it to the public, that things are kind of a mess here. And so when there's a mess, or where there is and the author uses this term later on, the re-enchantment or the disenchantment of such things, then you find the postmodern.
Yeah, that term when we were talking about ethics before, I liked the reenchantment.
Yeah.
That makes sense given what we learned about postmodernism, and it reminds me of this link to romanticism, historically speaking.
Yeah, that was a good introduction there about romanticism.
Yeah.
So romanticism, particularly in the 19th century, romanticism with a capital R, was a response to the ever increasing um, uh, categorization and introduction of science into things. Whereas previously you had found um, nature to be, something mystical, we'll say. Then now it becomes classified according to scientific means. So then romanticism was a reaction against this. It didn't go back to, fairy spirits or things like that. They kind of used it more metaphorically, but also definitely not letting the stress on feeling and emotion and artistic expression and things like that to
Hmm.
let it go by the wayside with science.
Yeah, like a large part of the modern era was this idea of being rational, and to the point that emotions are bad and we don't need to listen to them and that sort of
Yes.
thing.
Yes.
Yeah.
Okay. So Duzinus continues. Rules as normative propositions are supposed to prescribe general and abstract criteria of right and wrong, to anticipate and describe broad types of factual situations, and to ascribe legal entitlements and obligations to wide categories of legal subjects. Regulatory practices, by contrast, are detailed, specific, and discretionary. Okay, so when we're talking about justice here, or law in particular, it is by rules, juridical procedure, legal procedure, and so on.
Hmm.
So rules, normative propositions, they specify about right and wrong.
Okay.
But with regulatory practices, they're detailed, specific, and discretionary.
Okay.
For example, I don't know if it's the case in Canada, but definitely in lots of places in the States, whenever you're riding a bicycle, you must wear a helmet. That's not across the board. But
Yeah, that's generally a law here. I think in some places it's a law for children but not adults, but most places it's a law for adults too, if I remember correctly.
yeah, so I think it's generally required here in Washington D.C., but the exceptions are that if you use one of the bike shares or the scooter shares, you're not going to have a helmet on hand, but you're generally going shorter distances with those.
Oh, okay. Are those
Yeah.
like bikes that you rent or something like that?
Yeah, you have an app. You go with the service. There's I mean, there's what is it? 5 bike share companies now. I've used a couple of them. I especially like the Pedelecs, the electric bikes.
Oh, cool. I didn't
Yeah.
even know that's a thing, to be honest. That's cool though.
What, electric bikes?
No, the bike share thing.
Bike sharing. Yeah. It was a
Well,
company
actually
called Jump.
electric bikes too, yeah.
Yeah. So it's a company called Jump. They were bought by Uber, I think, earlier this year or late last year. So now you can just use your Uber app to either hail a ride, or if you find one of the bikes in the home area, you can just rent it.
Oh, okay. I was gonna say it sounds kind of like Uber. So yeah, that's interesting.
Yeah. Uber
Cool.
for bikes.
Yeah, that's cool.
Okay. So then continuing. Uh, the decline of legal formalism and positivism, the mainstay of modernism, led to a number of new approaches to law, which include critical legal studies, law and literature, law and economics, critical race and gender theories, and psychoanalytical jurisprudence. The first phase of postmodern jurisprudence addressed the form of law as a legal, moral, and political issue. Its second turned to the demand for an ethics and an attempt to develop a postmodern approach to justice and judgment. The essay follows in grad school a little bit of philosophy of
Oh,
law. Never
oh,
really
you
got into
got cut off for about
it.
10 to 20 seconds there.
Okay, so let me repeat that. So when I was in grad school, I took a passing interest in philosophy of law. That's a fertile ground, but I never really got too much into it because I had other interests. When you study the philosophy of law, you definitely start off with formalism, legal formalism, which is really stressing on what is the form of of the law, letter of the law, and so on. And then positivism, which is applying, I mean, this is positivism in general, which was a movement in philosophy in the 19th century, applying scientific methods to something that's not scientific.
I've heard about positivism a lot from when I've read about pragmatism.
Right. Yeah, pragmatism was a response against positivism.
Right.
So there was legal positivism, which I think its heyday was sometime in the early 20th century, particularly H.L.A. Hart, who was an English uh, professor. What is it called? The Concept of Law, I think it was, where he took a positivist approach. Okay,
Okay.
so formalism,
So,
positivism, this is modernism. But
so wait. Could you clarify what's the specific definition of positivism is?
so positivism is generally applying the scientific method to things that are not within science's purview.
Oh, okay. So it's like
Okay.
professional scientism almost.
Well, scientism is it's a fetish. Okay,
Yeah.
that's really elevating science to a level that it should not be at. However, you can apply some positivistic principles to, again, things that are not scientific.
Oh, okay.
Connected with this, there was a movement in the early 20th century called the logical positivists,
Right.
of whom Bertrand Russell and Gerald Moore were prominent members, and to a certain extent Ludwig Wittgenstein. This is the early Wittgenstein. So positivism was all about the verification principle, which is if it cannot be verified by scientific methods, not um, it's not bullshit, but it's irrelevant.
Oh, okay.
Okay,
Did
so
Wittgenstein change his mind about logical positivism later on in his philosophical career?
yes, so there's not a hard line, but scholars generally refer to the early and the later Wittgenstein. The early Wittgenstein was a positivist, or very heavily influenced by positivism. Later on, particularly around the time of the philosophical investigations, he abandoned that, as did most of the positivists, because they found that their verification principle was incoherent. It failed its own test.
What's the verification principle?
Oh, good question. I'm going to have to look that up. Give me a minute. Verification principle. Where was it? Okay, so verificationism, also known as the verification principle or the criterion of meaning, is the philosophical doctrine that only statements that are empirically verifiable, that is, verifiable through the senses, are cognitively meaningful, or else they are truths of logic. Okay, so the verification principle failed its own test. It could not be empirically verified.
Yeah, that makes sense. That
Yeah,
sounds like radical empiricism or something like that.
somewhat, yeah. Okay, so that's positivism and legal positivism here. So then, as the author says, the first phase of postmodern jurisprudence then started to incorporate things. The form of law is legal, moral, and political. Okay, so instead of law being a subject unto itself, you are looking at the moral implications of the law and the political implications of the law.
Kind
Kind
of
of
makes
makes
sense.
sense.
Yeah.
Kind of makes sense, yeah. And then the second phase was ethics, an attempt to develop a postmodern approach to justice and judgment. So, again, rather than looking at justice as something necessarily abstract, as is legal judgment, which is somewhat different from other forms of judgment, cognitively speaking, you introduce ethics into this. Okay, so
That's
which
why
we'll see shortly.
that's why it's good that we've gone over postmodern ethics already. Otherwise, I'd be lost.
Yeah, yeah, for sure. Okay, so now we're going to the next section. This is jurisprudence and modernity. Okay, so first, let's go ahead and give a definition of jurisprudence in case anybody doesn't know. So, jurisprudence or legal theory is the theoretical study of law. Scholars of jurisprudence seek to explain the nature of law in its most general form and provide a deeper understanding of legal reasoning, legal systems, legal institutions, and the role of law in society. So, in general, it is the theoretical study of um, law, not the practical applications of law, the theoretical approach to law.
So is it still lawyers who do jurisprudence, or is it some other different type of academics?
That's more legal professors.
Oh, okay. That
So
makes
if you go
sense.
to law school, you're definitely going to get a heavy dose of jurisprudence. What is the law? What is a tort? What is contrast? The first law, second law, and third law type of study. You have your theoretical basis of what that is that you find out in law school.
Right.
Even paralegals have to go somewhat through jurisprudence, although not to the same extent as a practicing lawyer would.
Oh, okay. Well, yeah, that makes sense, I guess. Yeah.
Yeah, and then there's some people in the law who never practice law. They just become legal professors or commentators, things like that. All right. So, continuing. The history of jurisprudence can be described as the history of the meanings of the word law. Yes. Generations of jurisprudence writers have subdued their readers by obsessively addressing the question, what is law? The concept of law, the idea of law, and law's empire are phrases found in the titles of some of the most influential jurisprudence textbooks. Jurisprudence set itself the task of uncovering and pronouncing the truth of law and approached the task by following two major approaches, the internal and the external. Internal adopts the view of the judge or the lawyer, theorizing the process of argumentation, and the external theory is the sociology of law, and Marxist approaches treats reasons, arguments, and justifications as, quote, facts to be incorporated in wider, non-legal explanatory contexts. That's the external. Okay.
Okay.
So continuing on, with normative jurisprudence, legal positivism has been the dominant and typically modernist internal approach. Okay, so this is what one scholar has called a pure theory of law, a discourse of truth about norms, which is right and wrong. The object of study was defined as the logical hierarchy of norms, presented as a coherent, closed, and formal system, a legal grammar guaranteed internally through the logical interconnection of norms, and externally through the rigorous rejection of all non-systematic normative matter, such as content, context, or history. Okay, so this is law purely as a theory of law, divorced from any context. Okay, so that was the positivist approach to law. Did it succeed? Probably not, because I don't think anybody really takes it seriously anymore.
What
Uh,
like what sort of jurisprudence is used now?
well, that's a good question. We're getting to that.
Okay.
So that was legal positivism. Now, the political dimension, the author continues, of the exclusion of morality should be sought in the modern experience of relativism and pluralism and the fear of nihilism. Law is presented as the answer to the irreconcilability of value and the most perfect embodiment of human reason. Okay. So, if nothing else, you can point to the law and say, there you go. Here's our standard. Law is a collection of normative standards, judgments, what have you. We can definitely rely on the law. We don't have to, we're not going to fall into the pit of nihilism, and we can address relativism in an effective way through the law.
I like that
That's
because
that,
those are what would be those are like what's the word I'm looking for? Like keywords, I guess people point to.
buzzwords.
Yeah, buzzwords like especially relativism when they criticize postmodernism. Like
Yeah,
they
I'd also
want
say,
everyone to be relative, everything to
no,
be relativistic.
nope.
There
I'd
again,
also,
that's not what they're saying.
nope. I'd also say it's a conceit because you think that law is above all that. But
Yeah.
aha, we will find out soon that it is not. At this crucial point, jurisprudence turned its attention to hermeneutics, the theory of interpretation, semiotics, theory of signs, and literary theory as an aid to the ailing enterprise of positivism. So already positivism was breaking down. The
Oh, okay.
hermeneutic turn expressed the deeply felt need for a return to morality. Okay, key point there. So if we are looking at legal documentation, now positivism has its limits, of course. It's no more, people are no longer taking it seriously. So definitely in the course of a text, how could you say that a legal text, really falls outside of interpretation? Sure, judges interpret legal texts all the time, precedents and so on. So
Yeah.
then when the hermeneutic turn came, you're now going back to, okay, so if we're talking about the law, where's the morality that's behind this?
Yeah.
Yeah.
Yeah, exactly. And that's where we come to postmodern ethics that we were talking about before. And
Yes.
I like what the author said there about incorporating literature
Hmm.
into figuring that out too. That's interesting.
Yeah, because literary theory, she continues, well, I'll say it's a he. He will continue here. The importation of hermeneutics, semiotics, and literary theory in jurisprudence was motivated by the urgent need to correct the descriptively inadequate and morally impoverished theory of law as exclusively rules, and to reinscribe morality in law. The new hermeneutical jurisprudence insists that the law is a valuable source of meaning and that it means values. Okay?
Right.
So with hermeneutics, the theory of interpretation, semiotics, what does the legal text signify? What is it pointing to? And then literary theory is criticizing it as a text, as a literary text, even.
Oh, okay, that makes sense.
Yeah. So using the categories, now there's the formalist literary theory, there's the Marxist literary theory. We won't get into that here, but there's many different schools of literary theory that you can apply here.
Oh, the evil postmodern neo-Marxist.
Oh no, the cultural neo-Marxists. No, no, they're taking over. Run for the hills, people. All right, back to sanity. The author continues. The literary and hermeneutical term gave legal theory a long lost sense of excitement. Mhm. But another effect was to make morality an integral element of law, and in particular of judicial interpretation. The new jurisprudence of meaning responded to the highly topical demand, as ethics became part and justification of the newly discovered interpretive character of the legal enterprise.
I think for people who haven't watched the episode on postmodern ethics, I was thinking it would probably be good to just do like a quick flashcard version of that.
Sure, well, I could make the distinction, as I have before, between ethics and morality. I came to the distinction, I described the distinction a long time ago, as that ethics deals more on rules
Hmm.
and forms of conduct. Just like when you're going to a job, you sign their code of ethics. I agree to abide by these code of ethics, not do anything funny, blah, blah, blah. Okay, so
Hmm.
that's your code of ethics.
Don't be
But morale,
grabbing women by the pussy.
that's right, things like that.
Hmm.
So morality is a little bit more, I'd say, sociological, maybe even um,
Psychological,
psychological, yeah. And,
sociological.
well, I said sociological, but
Oh,
more,
yeah, yeah, you did. Yeah,
I would say national, because morality can differ from country to country, from society to society.
yeah, it's true. Yeah.
Okay. Also, morality, going back to what we covered with the postmodernist ethics, is that the difference here is that when you are dealing with the other, we touched on this earlier, the other as something distinct from me that exists preceding categorization. How am I to address the other? I could address the other, or I could deal with the other through a code of ethics, but is that the most humane, or can we even say just way of dealing with the other?
Right.
Okay. Because again, with the whole thing about the positivist approach, this was all about formality, rules, and trying to make it into a science. But that fell flat.
Hmm.
It ran out of gas. All right.
Yeah.
So
Well,
continuing,
that's why science can't be applied to everything.
no, for sure. So continuing, morality and moral philosophy enter the law and are correctly recognized as an inescapable element of judicial hermeneutics. But their task is to legitimize a judicial practice that has been disassociated from the quest for justice by presenting the law as the perfect narrative of a happy community. Morality is no longer a set of subjective and relative values, as the positivists claim, nor is it a critical standard against which acts of legal power can be judged. All right? So, So we're not talking about justice here with judicial hermeneutics. Justice is something that's kind of separate from the law. Ostensibly, the law and the people who operate in it are seeking justice. But what really is justice? Is justice a product of correctly follow the letter of the law? Some might argue it is. Are others talking about justice as something that restores something that was lost to the person that was affected? Some would argue that it is. And we laugh at the term a social justice warrior, but those people are searching for some kind of justice, whatever their definition is. And it isn't legal necessarily. They might use the law to achieve their ends.
And as much as they get carried away sometimes, which is why they get criticized, they do, like, pursuing the idea of social justice is not a bad idea in itself.
No, it's not. But
Yeah.
again, what is the justice involved? Is justice also something that certain people win and others lose? Seems to be the case with a lot of SJWs. But is that
Yeah.
quote true justice that we're after?
No, I wouldn't say so anyway.
I wouldn't say so either. Okay, so continuing. Undoubtedly, the law is interpretation, and interpretation is the life of the law. The law may follow principles and further values, but there is more to it. Before and after the meaning-giving act, law is force. Okay? Statutes, judgments, and administrative decisions act upon people and impose patterns of behavior, attitudes, and ultimately sanctions. Okay. Continuing, we are thus faced with a new paradox. Power relations and practices proliferate and penetrate deep into the social, often taking a loose and variable legal form. Their common characteristics are few and often extremely tenuous derivation from the legislative power, and more importantly, they're linked with the increasingly empty referent, quote, law, which bestows upon them its symbolic and legitimatory weight. Okay, so now we're getting down to brass tacks here. There is power in law, relations and practices. Yes, you could deploy Foucault here, but not everything is about power. We just want to get that out of the way.
Yeah, Foucault doesn't say that either.
No, didn't say that here. Power relations, no such thing as real power. Okay.
Yeah.
And then towards the last of the section, power is legitimate. Yeah, okay. So from this, it follows that law is the form of power, and power should be exercised in the form of law. Power is legitimate if it follows law, nomos, and if nomos follows logos, reason. So nomos is the Greek term. Logos is the Greek term too. Nomos is where you get the term nomological.
Right.
Following some kind of a norm or following some kind of a law. This peculiar combination of the descriptive and prescriptive, of logos and nomos, lies at the heart of modernist jurisprudence. Okay. The task of postmodern jurisprudence has set itself is to deconstruct logo-nomocentrism in the texts and operations of law. The hermeneutical moral turn in jurisprudence was welcome, but the moral substance of law must be argued and fought for rather than simply assumed.
Wait,
Furthermore,
what's logo-nomocentrism?
I'll get to that in a minute.
Okay.
Furthermore, in order to understand justice, the specifically legal facet of morality, we must link it with law's force. Postmodern jurisprudence abandons the key premises of amoral positivism. Key point there, positivism was amoral, and of a too moral but powerless hermeneutic jurisprudence. Okay, so logo-nomocentrism. This is a riff on logocentrism, which we find in Derrida. Okay, so first, what is logocentrism? Let me make sure I get my definition correct here. Give me a moment. Okay. So actually, the term logocentrism does not originate with Derrida. A German coined it in the early 1920s. It refers to the tradition of Western science and philosophy that regards words and language as a fundamental expression of an external reality. It holds that the logos as epistemologically superior, and that there is an original, irreducible object which the logos represents. According to logocentrism, the logos is the ideal representation of the Platonic ideal.
Okay.
Okay. So Derrida was not the first to coin it, but he was the first to kind of popularize it. He was criticizing logocentrism in his project in deconstruction. Now that's logocentrism. Logo-nomocentrism is taking the logos and the nomos, which is of the law, in the text and operations of law. So in logo-nomocentrism, you prioritize reason and you prioritize law within the text and operations of law.
Oh, okay.
Okay. Again, the Platonic ideal. We've covered
Right.
this in the delusional podcast too. We know what the
Right.
Platonic ideal is. So any texts and operations of law are reflections of the logos and the nomos.
Right.
Okay. So logo-nomocentrism is this prioritization, but postmodernism is going to address that and try to turn it on its head.
Okay.
Okay.
Yeah.
Question so far?
No, I think that makes sense with the logocentrism and logonomocentrism. That makes sense.
Mm-hmm. Yes. Good term.
Yeah.
All right, next section. So we are deconstructing law's formalism. Author continues. The starting point of postmodern jurisprudence is the recognition that postmodern legality defies both the positivist and the moralistic image. We already saw this. The condition of postmodernity has irreversibly removed the aspiration of unity in law. Everything that successfully attaches the term law to its operations and mobilizes the coercive force of the state becomes law. Let me read that again. Everything that successfully attaches the term law to its operations and mobilizes the coercive force of the state becomes law. So an
Oh, okay.
important point in there. The power coming from the state, because, stop and think about it, what is the ultimate authority of a law? The power of the
The
state.
state. Yeah.
Okay. In this sense, the law can be constituted not theoretically, but only intuitively and politically. The law has no essence, but only operations. So again, this is against positivism, which said that there was kind of a pure theory or an essence of what the law was.
Right.
Okay. Methodologically, postmodern jurisprudence, unlike contextual approaches, carefully reads legal texts and legal history and treats them as the privileged terrain of study. But unlike internal theories, it reads these texts not just for their normative coherence, but also for their omissions, repressions, and distortions, signs of the relations of power and symptoms of the traumas created by the institution. Okay, so this description here is a hallmark of what deconstruction is.
Yeah, for
Okay,
sure.
so what is
Using
deconstruction?
it's
Yeah, so quickly.
using the language of whatever you're criticizing and the positions of it to criticize it and basically deconstruct it by analyzing each part and kind of critiquing them to the point where they don't make sense or something like that. That might have been a more verbose explanation than is required.
I think it is. So let's be careful about this. If you were to solely go by the language itself, you're getting into semantic issues. What does this mean? What does law mean? What does legal mean? And so on and so forth. That's more of a semantic issue. When looking at the text itself and its legal history, is that you're looking for not what's being said, but what's being not said,
Right.
exposing what its
Yeah.
contradictions are. Okay. So I'm not going to give an example here, but you can theorize is that whatever you're reading, and in particular, we're looking at a literary text or even a philosophical text, which is definitely what Derrida is doing, is what are the presuppositions here? What are the assumptions that are at work? What does it not say? What does it get wrong? Where it's not clear at first reading. That's what deconstruction sets out to do.
Yeah. Yeah.
Okay, so jurisprudence is obsessed with order. Its task has been to present law as a system that follows a strict logic of rules, or a disciplined and coherent arrangement of principles, a procedure that would, it is hoped, give law identity, dignity, and legitimacy. The corpus of law is presented almost literally as a body. It must either digest and transform the non-legal into legality, or it must reject it.
Oh, I like that.
Yes, I like that too. Continuing. Early postmodern jurisprudence adopted three deconstructive strategies that addressed in turn the concepts, the argumentation, and the discursive organization and intertextual character of legal texts. Okay, so the first one, concepts and conceptual change. So for key jurisprudential and doctrinal concepts, they can't deliver the conceptual homogeneity or doctrinal coherence they promise. Criticism number one. The rule policy opposition permeates tort and contract. Tort is about wrongs. Contract is about writing contracts. While the opposition between universalism and cultural relativism, or communitarianism, has dominated the
Buzzwords.
debate on human rights. Yes. Okay, let me read that again. The rule policy opposition permeates tort and contract, while the opposition between universalism and cultural relativism or communitarianism has dominated the debate on human rights. Key points here.
Yeah.
So, rules do not apply really to human rights, neither do policies, at least according to the author here. Human rights are either universal or they're relative to a particular culture. But that's a debate that still continues.
Okay. Yeah,
right?
that's interesting. I'd say it's kind of both.
How is it both?
Well, no. I guess if you have to choose between universal and relative, I just mean that it seems somewhere in between universal and completely relative. Like there could be, like, do you know what I mean? Or am I not being clear?
That's what the debate is. So if we're looking at
Okay.
human rights, let's say that somebody's human rights have been violated. Okay.
Mhm.
So number one is, all right, when we're talking about human rights, are we talking about everybody, which is the universalist claim, or are we talking about something that is relative to the particular culture, like
Oh,
Canadians
okay.
versus Americans versus Germans versus Bangladeshis or whatever it is? Okay, so you get that straight. Then if you're talking about, if you say somebody's human rights have been violated, all right, so that's where torts come in. Now it is, how do you address what the wrong is? What is the rule that you use to address the wrong, the violation of the human rights, and what is the policy associated with that? But you're
Yeah.
not talking about that. This is the way the author explains it. But you're not talking about that at once when you're talking about human rights.
Right. Yeah,
Okay.
yeah. And that makes
A
sense.
particular
Yeah.
wrong, it does not apply to everybody. I was wronged. Okay. Somebody robbed me. Somebody broke into my house. That
Yeah.
doesn't apply universally.
And like different countries have different sets of laws and so on and so forth.
Right. Right. All right. So the author continues. To take an obvious example, judicial reasoning is distinguished into the grand and the normal styles. All right. The former emphasizes policy concerns and discretion. This is the grand style. Claims to follow the intention of the legislator and the purpose of the rule, and examines the wider social desirability of alternative outcomes. The latter, the normal style, claims strict adherence to the rules, interprets literally, and promotes judicial abstinence when gaps appear in the legal edifice. A related and pervasive conceptual juxtaposition is that between rules and policy. Rules are said to make for certainty, predictability, and fairness, while policies and direction are said to make for substantive justice, adaptation to the contingencies of the situation, and purposefulness in interpretation. But while the terms of the opposition are presented as external, they depend for their existence on the difference that separates them.
Oh, I like that. That makes sense.
Okay, let me read that again. Rules are said to make for certainty, predictability, and fairness. It's kind of intuitive in a way. While
Mhm.
policies and discretion are said to make for substantive justice, adaptation to the contingencies of the situation, because we know that a rule can apply in every situation, and purposefulness and interpretation. Rules also don't afford for interpretation. It's just you follow this rule. But while the terms of the opposition are presented as external, they depend for their existence on the difference that separates them.
Yeah, of course. Because otherwise how can you determine what those are specifically, right? It's like it reminds me of like what we've been learning about Deleuze, like his philosophy of difference, because
Mhm.
our differences are how we define something, like by comparing it to something else.
Right. Instead of falling to identity,
Yeah,
particularly
exactly.
a fixed identity.
Yeah, exactly. Because no
Okay.
identity is like fixed.
Right.
Yeah,
Okay. So continuing. Doctrinal construction presents a part of law as a closed structure of norms that cohere according to formal principles of non contradiction, meaning it's either A or B, not both.
yeah,
Okay, rule extraction is the result of judicial institutional power rather than of textual or normative closure. So, in other words, you can't tease the rule out of the text. The rule is set in motion by whatever the power is. So if the judges come up with a code of rules, they're flexing their power. What they pull out of the text says X, Y, and Z. So we are creating a rule from this text that everybody must follow, and we enforce this.
right.
Okay. So continuing on, these problems that are associated with the conceptual law, cannot be avoided by using the context of the rule or the text. The indeterminacy is not resolved by adopting a constructive approach to interpretation and attending to the intention of the legislator or to the context of the judgment. While legal interpretation takes place in the context of a particular conflict, every context in itself is a text that needs further interpretation. Interesting point. Okay. So, in other words, to avoid problems that come up with conceptual clarity or conceptual incoherence that might arise, you can't just point to the context and discern whatever the rule of the text is by using the context. Why? It's because the context itself is a text that needs further interpretation. The context is not fixed.
Right. Yeah, of course, because it
Okay,
always changes.
right. All right, so the second problem are argumentative inconsistencies. Duzinus continues. Motivated by the desire for clarity, rigor, and coherence, legal argumentation moves to its conclusions in an effortless manner, in which argumentative development and closure follow naturally from the premises, and any embarrassing evidence is treated as insignificant exception. Yet a close reading of the text often reveals contradictions, disparities, and conflicts within and between argumentative lines, which frustrate the promises of closure of the text and open possibility the textual surface ignores. Okay,
Yeah.
so in other words, legal argumentation is not cut and dried. It might think it is, or its proponents might think it is, but there's a lot that's being left out and quite a bit that is also contradictory, and that doesn't apply to every situation, obviously so. Okay?
Yeah. Yeah, that makes
So
sense.
the author says, take, for example, the well-known rules on offer and acceptance and the law of contract. Contract law assumes a representational model of language, according to which ideas, thoughts, and the acceptance of the offer, I am offering you something in this contract, are first formed in the mind of the contractors and then communicated in linguistic form. Once the minds have, quote, met through the assent of the offeree, the contract has been completed and is binding on the parties. Okay? So if you and I draw up a contract, we each have an idea of what we expect in this contract. I want X, Y, and Z, you want A, B, and C, and we meet in the middle ground. So then the contract and writing up the contract, I offer you the X, Y, and Z, you offer me the A, B, and C in return.
Hmm.
And then the language that we put in the contract represents those thoughts and those ideas, puts it on paper, we sign it, and then the contract is binding. Okay, that's the, shall we say, the naive realist approach to what a contract is.
That's a good way of putting it.
Yeah, now the next time you sign a contract, just try and say that, well, this is all a text that is subject to interpretation, and see what kind of response you're going to get.
I
But
don't
but
think they
we're
would
only
care.
operating within the realm of theory here.
Yeah,
Okay,
jurisprudence, like you said, not actual
right.
law practice here.
Right. Jurisprudence. All right. All right. So continuing, the law of communication and agreement relies on interference and disagreement. And as the textbook states, this is a textbook dealing with a case in early 19th century about contract law. This is a common occurrence in common law. The exception, the law of the letter and of writing, puts the law and contract into circulation. Okay. So the contract, when you write it up, and then whatever the law of the letter is, puts the contract into circulation. Otherwise, the contract really doesn't exist. It comes into being by the law of the letter and of writing. Okay.
Yep. Yeah,
But
that's a good way of describing it too.
yeah, but the law of communication and agreement relies on interference and disagreement. Okay, so in coming up with a contract, we're trying to attain some kind of an agreement, but we're already starting from a standpoint of some disagreement.
Yeah, of course.
Okay. And that is, the argumentative inconsistencies. And then the last one is intertextual possibilities. Okay. Dosinas continues. Legal documents display discrepancies and inconsistencies arising from the fact that their various elements, parts, and layers, with their different roles, functions, and operations, are brought together with quotes and grafts from other texts, must survive an uneasy and an unstable combinations, and become authoritative in various unpredicted and unpredictable new contexts. So, in point of fact, particularly for American law, I think it's English law in general about precedent. Okay. So in
Mhm.
coming up with a judgment for a particular case, you refer to whatever the precedent is. And then, I've never practiced law. I never had any desire to, but I've been around enough lawyers to see when they draw up their briefs. What do? They conduct research, they excise text, they stick it in there and say, referring to this case from 50 years ago, whatever it is, the precedent, in support of the argument for why something should be or why something should not be the case.
I've often thought before that I might like a few aspects of being a lawyer. One that I like arguing. Another
Yeah.
one is that I like doing research, but I wouldn't
Yeah.
want to have to deal with all the other shit that I'm sure is involved.
Well, then become a paralegal.
Yeah, exactly.
Because you know what the paralegal's job is?
What?
To do all the research.
Oh, yeah, that's true. I don't
They
want
don't
to
have
have
to
to go
plead. They
through
don't have
all
to
the.
plead cases in court.
But you have to get a law degree for that, though.
Well, you have to have some kind of law study, but you don't have to get a JD, a Juris Doctorate. You can just get a certificate or whatever it is to be paralegal, and then you get some law firm to hire you.
Oh, that's interesting. I didn't know that.
Yeah, might be something to look into.
Yeah, maybe.
I think there's also a market in that too, with more legal research going online, third parties.
Oh,
So
yeah.
I remember coming across a lawyer. He was not from a top tier law school. He was from a mid range school, and we got to talking. And said, "You know what a lawyer is? Really, a glorified paper pusher." And I said, "You got a point there." And he's right, because the majority of the work that lawyers do, well, first they get their paralegals to do a lot of the research, and then they offer the research up to the attorney, who is in the process of putting together the brief if they're going to plead something in court. And most of the time, they never go to court. They kind of settle out of court. But they're
Oh,
also dealing with lots of other documents, like if they're a licensed notary, then they can notarize documents or file paperwork, wills, trusts, all that stuff. That's where they're a glorified paper pusher. They rarely ever go into court.
oh, okay. Yeah,
Yeah.
it sounds like a pretty cushy deal.
Yeah. So yeah, I would look into to become a paralegal. I mean, if I was ever so inclined to go to actually work on the law, I probably would be a paralegal. Screw being a lawyer; it's not worth it.
Yeah, definitely. So like even just getting a law degree, like fuck that.
Oh, it's a major pain in the ass.
Yeah.
And then you got to sit for the bar exam. I don't know. Do you guys do that in Canada? That there's a provincial bar exam. So if you're licensed to practice in Alberta, you have to go sit for a separate exam in Ontario. things
I
like that.
really don't. I really don't know. I'm sure there's something equivalent to that, but I don't know.
Yeah, I'd be curious to find that out. That's usually how it is here in the States. You have to sit for the state bar exam,
It w-
cover a wider range of states, not just separately.
it wouldn't surprise me if that were the case, but because that is similar to how a lot of things work here in Canada. Like even things that are federally instituted, they're um, like if there's a federal law, it's instituted separately by each individual province, and there might be some slight differences. So, I mean, given that, it wouldn't surprise me. But like I said, I don't know.
Yeah, it's the same here in the States. There's the interpretation that the states can make of the federal law, only to a certain extent.
Yeah,
But in practicing law, you have to be licensed to that state's bar,
right.
including the District of Columbia, which itself is not a state.
Oh, okay. Yeah, that's true. Oh,
Yeah.
so just within. Oh, right, right, right. No, I was gonna ask a question that I figured out the answer to before I asked it.
Yeah, I'm
Yeah.
not quite sure. I would assume, although I'd have to look it up, is that if you sit for the bar exam for the District of Columbia, there might be reciprocity with Virginia and Maryland that border DC. Because number one, DC is not a state. Number two is when you're talking about the DC area, it is also Northern Virginia and Southern Maryland that abut that border on DC. It's the
Right,
wider DC area.
right.
The
Oh,
city of
okay.
Baltimore is a separate case. That's definitely you have to be licensed to practice in Maryland.
Oh, okay. That's
Okay.
interesting.
Yeah. But pressing on. All right. So, with intertextual possibilities, continuing. Judgments in law reports are a case in point. The evidence offered in trials and recorded in the reports is not constructed and evaluated against some hard external reality. On the contrary, the construction of the relevant law, the major premise of the legal syllogism, and fact finding, the minor premise, follow standard and coherent narrative frameworks drawn from the stock of specialist and common knowledge. Okay. So, with the hard external reality, this is what legal positivism is trying to do. What is the
Okay.
letter of the law? What is the spirit of the law? The pure theory of the law, and so on. So, that's not the case. When you're looking at a precedent, for example, the precedent could be from 1860. Okay. Things were different back in 1860 when they came up with this precedent.
Yeah.
But it exists, and you refer back to that because there might be some insight in that precedent that you don't have to go through the entire rigmarole in the court to arrive at some decision that might have already been decided over 150 some years ago.
Right. Yeah.
Right.
Good
But
point.
there is a coherent narrative framework from the stock of specialist and common knowledge, which is what all lawyers have. You know, there's the common legal knowledge that you learn in law school, and then there is your specialist knowledge to whatever you are. Are you a criminal prosecutor? Are you a district attorney? Or are you a public defender? Do you work just in antitrust law? Are you a divorce lawyer or things like that?
Mm-hmm.
Okay,
Yeah.
continue.
Makes sense.
Yeah, so continuing. The potential for multiple formulations of facts and law of both the present and the previous cases, and the continuous dialogue of legal texts with non legal contexts, creates a fertile ground for alternative readings. Yeah, no shit.
Mm-hmm.
One strategy concentrates on the discrepancy between the surface arguments of the text and its rhetorical organization. Legal texts, like a certain type of philosophy, have always aspired to a state of linguistic transparency in which the clarity and rigor of argument will not be contaminated by the quote, irrational and devious figures of speech. Plato fired the opening salvo in this campaign by expelling poets from his Republic, for example.
Oh,
Okay,
I didn't remember. I didn't know that.
right. So if you read the Republic, Plato really does not have a good word to say about sophists.
Yes.
He does not have a good thing to say about poets or artists. Why? It's because poets and artists are not dealing with the ideal form,
Mm-hmm.
only a copy or a representation of it.
Yeah.
So, in the long line of philosophical tradition, what philosophers have tried to do in writing their texts is to approach some kind of narrative that exists, even though they might not say it is. They certainly have relied on argumentation, but whatever they write is transparent to those who read it.
Mm-hmm.
Okay. And it does not, they do not, or at least try not to, devolve into being a sophist using rhetorical flourishes. They might use rhetorical flourishes, but they are not trying to necessarily convince you by just rhetorical flourishes. They're
Right.
trying to argue a case. Now, as we're seeing in the case with Deleuze has his own readings of people that we've already covered, such as John Duns Scotus, Leibniz, Hume, and so on, to tweeze out of there things that were not said.
Mm-hmm.
Kind of a deconstructed reading, even though he was not really on board with deconstruction at the time. Actually, deconstruction kind of came a little bit later because empiricism and subjectivity, his first book on Hume was 1956. This was
Oh,
before
okay.
Derrida really started to gain steam.
Oh, okay.
Okay, so the point here is that, you know, people who wrote legal texts, just like philosophers, have strived to assume that what they write is transparent to the educated person, and that they are avoiding anything that would sway somebody's opinion by using rhetorical flourishes.
Right.
Okay, so
Oh, so
continuing on.
that's why it sounds boring.
That's why it sounds boring. Yes, it's dry as dust. Yeah.
Yeah. Sounds
All
like it
right.
was written by a robot when you look at
Yeah.
any legal document.
Yeah. All right. So continuing. If it is true that legal texts have many contradictory, paradoxical, and conflicting meanings, what is it that keeps texts together, authorizes one interpretation over against possible others, and gives them their power to order the world? The urgent task was to explore the ethical dimensions, to find methods of distinguishing between the flippant and the fundamental, the worthless and the worthwhile, without in any way reinstating the modernist claims to the power of authority. This was the point at which postmodernism generally went political and ethical. In law, it meant a turn towards justice and the operation of judgment.
Okay.
Okay, that makes sense?
Yeah.
All right. Next section. The ethics and justice of alterity. Okay, so alterity is that theoretical philosophical term that means otherness.
Right.
We're dealing with another. All right. So, Dusinus continues. Contemporary jurisprudence identifies justice fully with the law. Legality, the rule of law, the impartiality of the judiciary, the correct following of formal procedures are the main topics in the discussion of justice. Law is seen as the main answer to the weakening of authority and the moral polyphony of modern society.
What's polyphony mean?
Polyphony means many sounds.
Okay.
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 All right. So, the rule of law, legality, the rule of law, the impartiality of the judiciary, basically assume this, the correct following of formal procedures, the main topics in the discussion of justice. And this is the counter to positivism waning, authority weakens, and there are many competing moral claims in modern society. There's not one or two or a very small set that you can rely on.
Right.
Okay. For example, you cannot rely on Judeo-Christian values necessarily in the law. Why? It's because not every
Don't say that to some people.
not everybody abides by, I mean, in contemporary society, particularly North America, by Judeo-Christian values.
No way. You mean they're not
Say it
for
isn't.
everyone?
Say it isn't so. I know. All right. Continuing. Law excludes from its domain considerations of value and limits the quest for or the application of any substantive criteria of justice. The law becomes the main substitute for absent ethics and the emptied normative realm. Indeed, the very absence of ethical value, the flight of justice, ensures the morality of the law. So, in the absence of ethics and any kind of normative operations, then things become, wait for the term, legalistic.
Ah.
Okay. We've seen this play out many times.
Yes.
Okay. But that's a poor substitute. Positivism waned. Positivism put the whatever, the spirit, the pure law was an authority. This is from which the authority of the law derives. But
Hmm.
positivism is on the wane. What are you going to do to replace it? You have all of these other things that are creeping into society. You can't rely on what came before anymore. So what happens? Things start to become a little bit legalistic, particularly if there's no ethics that binds these.
You want to give some examples of that?
Well, you go ahead and do that. So can you think of any examples where that might be the case?
Where things get legalistic?
Where things get legalistic. So, um, I mean, it kind of makes sense because what people are doing is they're trying to find some kind of rule or standard by which to make a judgment.
Hmm.
Okay, so there's no central authority anymore. That's gone. You can't apply a positivistic or a scientific, sort of scientific, a pseudoscientific approach to the law. That's gone.
Hmm.
So what do you do with different cultures, different ways of conduct, different languages even? And how are you going to deal with, or especially deal with any kind of differences or problems that arise with other people? Okay.
Good
So
question.
if you are an atheist and you're dealing with a Muslim, for example, what's the
Hmm.
common ground by which you're going to address the differences between you and he?
Um, hmm. I mean, common humanity, I guess.
Okay. That's it's a fair assumption. I think that's an uncritical one though.
No? Or yeah, how so?
No, I mean you could do that, but what's the success rate for that? Who knows? I don't think it's very high.
Yeah, I don't know.
And really, in the absence of that, I think you've been around long enough to see what do people kind of default to?
They default to either either maybe cultural or like trying to impose a shared culture of that area on it, or I think it sounds like what you're getting at is looking at them from a legal perspective.
Right. They look at it from a legal perspective. So um if okay, you're an atheist and then there's a Muslim. You rear end the Muslim's car. Okay. So I think this is the same case in Canada, is that you guys exchange insurance information. By law in the States, you are required to carry insurance.
Hmm.
If you're not, you can get in serious trouble for that.
Pretty sure that's the same in Canada.
Right. So there's already a legal precedent that exists because you have to carry insurance and he has to carry insurance. However, what happens if culturally he says, I don't carry insurance because it's against my religion, using that cop out, or it's not a cultural practice that I operate by.
Right.
So you have abided by the law. It is required for you to do so, and you have done so. Yet, how are you going to redress this difference or this wrong? You could say, he could have rear-ended you. How are you going to address this wrong? Well, your natural inclination would probably be to go to the legal. I
Yeah.
mean, you exchange information, of course. If he has insurance, but if he doesn't have insurance, then how are you going to get your car fixed? If he
Yeah.
slams into you and it's totaled, you're kind of shut out of luck for the time being. So you want recompense, and that's a legal action. But what are you going to do when he's kind of outside the legal um, orbit?
Well, then
It-
you wouldn't be able to have the law help you in that case, and because
Or, the law will help you, but then you have to shoulder a lot of that burden yourself. I mean,
yeah, yeah,
your insurance would compensate you, but then you have a cost. Your premiums could go up or something like that.
yeah.
Okay.
And the law doesn't care whether you believe it's a good idea to get insurance or not, too.
Right. They don't care.
Yeah,
Now, one thing you can count on is that people will follow the law
yeah,
because they tend I think intuitively, this is kind of intuitively, is that they follow a consequentialist approach. Well, I better follow the law because I don't want to get in trouble if I don't.
It depends on what laws we're talking about, though, because a lot of people jaywalk or disobey drug laws or cheat on their taxes or all sorts of other
Yeah,
little things.
that's right. That's right. So they kind of follow the law, but if they can find a way to get out of it, they would find a way to get out of it.
I think most people exceed speed limits too.
Well, and that brings up an interesting case because, as libertarians like to criticize, and I think they're right, is that there are so many laws that are on the book, you're not aware of all of them. You're probably breaking at least 5 to 6, maybe even 10 laws a day without even knowing it.
Yeah, I think that's a good
Yeah.
point too. Yeah,
Like if you jaywalk across the street, people here in DC do that all the time. Cops
yeah.
don't pull them over.
I've jaywalked in front of cops many times and they've never done anything.
Yeah.
Well, maybe
I
not
mean,
many times, but at least a few times.
they could arrest you, but they got more important shit to worry about.
Yeah.
But you're breaking the law. You're jaywalking.
Hmm. They got to
Okay.
prioritize, I guess, as cops, right? Like
Yeah.
to go on the extreme opposite end of the spectrum. If someone's getting murdered or something like that, that's way more important than someone jaywalking.
Yeah. Now, if the person was murdered while they were jaywalking, well, okay, and then they killed two birds with one stone there.
Yeah.
All right, so Dizzinus continues. Postmodernity brings to an end the exalted attempts to ground moral action exclusively upon cognition, reason, or the law, and marks the beginning of a new ethical awareness. Bye-bye, modernism. But the rethinking of ethics and politics or of justice and the law must pass through a new conception of the good. In a situation where classical teleology, which is focusing on an end, is historically exhausted and religious transcendence is unable to command widespread acceptance. Good point. The modern cosmos has been disenchanted and does not carry, as in classical times, meaning, purposes, and values that can ground in ethics. Natural laws are the concern of scientists, not of moral philosophers. Okay,
True.
so by modernism, also, there is no end purpose which we are shooting towards. That's what teleology is. And there is no religious transcendence to command widespread acceptance. So even if you do have some religiously oriented type people, they might be in the minority of a society. So you can't rely on whatever God says is the ground of your morality.
Yes, breaking down a modernism.
Breaking down to modernism. Okay. So then there's meaning, purposes, and values that in ethics, but what are they? We don't know where they are yet, and they might be in conflict with others. So I like that last line. Natural laws are the concern of scientists, not of moral philosophers.
Yeah, me too.
Okay. And with that, we segue into Levinas. All right, Emmanuel Levinas. Duzzinus continues, and this is a resummation of what we covered in the ethics essay. Levinas argues that Western philosophy and ethics share a common attitude towards the world, which reduces the distance between self and other and makes the different follow the same. Classical philosophy promised to reveal the structure of reality by claiming that the realm of beings follows the laws of theoretical necessity. In modernity, individual consciousness has become the starting point of knowledge, and as a result, what differs from the self same has turned into a question of knowledge, an exploration of the conditions under which I can know the other's existence and understand his or her mental life. The ethics of alterity, otherness, challenges these ontological and epistemological assumptions. It starts with the other and challenges the various ways in which the other has been reduced to the same. The other is not the self's alter ego, self's extension. We also saw this with ethics. Nor is the other the negation of self in a dialectical relation that can be totalized in a future synthesis. Okay?
Okay.
Makes sense there?
Yeah.
All right. Yeah, so in the ethics essay, they also talked about the same. So using the ontological and epistemological assumptions. So you as the other, you and I think the same. You and I might have the same values. You and I might have the same hopes and dreams.
Mm-hmm.
Okay. So the modernist approach, you could say, you are an extension of me
Right.
because I'm me and I know my own experience better than anybody else.
Naive realism.
Well, not just naive realism, but it's also I assume that there is another mind with the other, but I'm assuming
Right.
certain things about my mind that apply to you as the other,
Yeah.
and you vice
Exactly.
versa. Okay.
Yeah.
So continuing, the other comes first. He or she is the condition of existence of language, of self, and of law. In the philosophy of alterity, the other can never be reduced to the self, or the different to the same. The demand of the other that obliges me is the quote essence of the ethics of alterity. But this quote essence is based on the non essence of the other, who cannot be turned into the instance of a concept, the application of a law, or the particularization of the universal ego. This is that third term that we talked about in the ethics essay.
Oh, okay. Okay.
Okay. As the face of the other turns on me, he or she becomes my neighbor, but not the neighbor of the neighbor principle in law. As absolute difference and otherness, my neighbor is also the most strange and foreign. The appeal of the other is direct, concrete, and personal. It is addressed to me, and I am the only one who can answer it. The demand does not depend on universal reason or law, but on the concrete historical and empirical encounter with the other. It is this situated encounter, an unrepeatable, unique demand, that assigns me to morality and makes me may abound an ethical subject. Our relationship is necessarily non-symmetrical and non-reciprocal, as his or her unique demand is addressed to me and me alone. Equity is not equality, but absolute dissymmetry. Dissymmetry.
Ooh, I like that.
Okay, so let's look at this in the case of charity. Good example here. You can look at, I have X number of dollars that I want to donate to a particular charity. The charity gives you information about those that are most in need, a list of folks, and where my money could best be utilized. I cut them a check and then I go along my way and they go along their way. Okay,
Mm-hmm.
very impersonal. If I use it within the certain ontological, epistemological, and even legal assumptions, that would make sense. Well, these people are not quite like me. They may be deficient. They don't have things that I do. So I want to cut them some slack. I'm going to give some of my money, which I'm not using, to help them out. And I trust that the charitable organization will judiciously use that money to help them and provide me with a report later on. Okay, very
Mm-hmm.
impersonal. However, were I to meet one of those people on the street, I can't apply those same strictures to that person. I'm
Yeah.
immediately confronted with that person. Say it's a homeless guy who just took a
Mm-hmm.
shit in the street. Okay.
Yeah.
I mean, I'm gobsmacked by encountering this person, and I really do not know how to deal with this guy, except maybe saying hi
Yeah.
and then trying to start a conversation.
Yeah.
This is what the point is.
Yeah. It's harder to do it when it's more directly personal like that, right?
Right. Yeah. So this is where, I mean, in the top of the paragraph is, he or she is the condition of existence of language, of self, and of the law.
Right.
Okay. Keep that in mind. So Duzinus continues. Legal rules ensure equality before the law and guarantee the freedom of the parties. But this equality is only formal. It necessarily ignores the specific history, motive, and need that the litigant brings to the law in order to administer the calculation of the rule and the application of the measure. So, in other words, the law says if you and I are equal before the law, however, we are not equal in our histories, motives, and our needs.
Right.
Okay. Legal rules and their mentality are strangely amoral. They promise to replace ethical responsibility with a mechanical application of predetermined and morally neutral rules, and justice without the administration of justice. But there is more. Moral philosophy, in its ontological imperialism, creates the generalized other. I like that term, ontological imperialism.
What does that mean?
Well, ontological, we're dealing with beings.
Hmm.
Imperialism, imposition upon another.
Oh, okay. Right.
Okay.
Yeah, that is a great term. Yeah.
Okay. So continuing, ethical responsibility starts with the demand of another and the call to responsibility. But the law must also introduce the demands and expectations of the third party. Quote, the other is from the first the brother of all the other men. Coexistence places a limit on infinite responsibility. When someone comes to the law, he or she is already involved in conflict with at least one more person, and the judge has to balance the conflicting requests. The judge, seen from the perspective of the litigants, is the third person, whose action removes the dispute from the domain of interpersonal hostility and places it within the confines of the institution. So, in other words, what's your guys' beef? Let's take this and put it into the legal perspective, and let's try to divorce it from he said, anything else that might be associated with this. Because the third is always present in my encounter with the other, the law is implicated in every attempt to act morally. But the law limits our infinite responsibility for the other and introduces calculation, synchronization, and thematization. It regulates and totalizes the demands put before it. The law translates these requests into the
Universality?
universalizable language
Oh,
of rights, legal entitlements, and procedural proprieties, and makes them appear contemporaneous and comparable. Almost by definition and necessity, the law forgets the difference of the different and the otherness of the other, and in this case, it cannot escape injustice. To say, therefore, that the law begins as ethics, as the infinite, non totalizable, and non regulated moment of the encounter with other, sounds counterfactual.
okay.
Okay? Did that make sense?
Yeah.
Okay, sure.
Well, could
You
you
look a little puzzled.
just go over it once more?
Okay, so let me try to unpack this. So, using Levinas again, when you are confronted with the other, and I gave this example of the homeless guy, there is an infinite responsibility for the other, so he says, that is not mediated by any third term.
Yes.
Now, I could classify this is a homeless guy, this guy looks a little crazy, whatever it is. So I'm already starting to apply categories to him. But he and I are not in a legal situation. If we were in a legal situation, then the infinite responsibility that we have for that person has already been curtailed by the law because we are only operating within the confines of the legal. Okay.
Okay.
So, say that homeless guy lunges at me and he punches me in the stomach. All right. So he's now wronged me. And I want justice for that. Or I could just let it go. Depends on me. Legal confines, he committed assault. So that's a crime he committed against me. Make sense so far?
Yeah.
Okay. So the law, as Dozina says, translates these requests into the universalizable language of rights, legal entitlements, and procedural proprieties, and makes them appear contemporaneous and comparable. So here's where I think it would be profitable for people that are listening to this to really take some of the insights here and apply it to all this talk about human rights. Because human rights, earlier on, is really when you're talking about, is it universal or is it culturally relative type of a thing? That's human rights. But
Hmm.
that's all within the larger purview of the law. Okay? Because argue what you may about human rights might be inherent. You're born with human rights, but the law is definitely involved in this, and the law circumscribes some what could you do about human rights. Your human rights have been violated. You deserve recompense. Well, that's where the law enters the picture.
Mm-hmm.
Okay. So, however, it says the law forgets the difference of the different and the otherness of the other. So, although you think you are seeking justice and appealing to the law, there still is some injustice being done. Make
Yes.
sense?
Yeah.
Okay. Because I have not been around numerous court cases to see what it is like. But I've been around enough where there's always something that's missing or always something that is not to really anybody's satisfaction 100% whenever a court case is adjudicated.
Mm-hmm.
Something is always lost. Like in the case of, say, a murder trial. So the murderer is found guilty. Okay. Justice has been served. Has it really? Because number one is the murdered person's family will never get to see their loved one again. So they even though they might have a monetary value, they might get a payout from that, damages. They're never going to get that person again. So there's already a lack there. Some injustice was done. And more importantly, that person who has been accused of the murder is going to go to jail. But is jail really the just means of doing things?
Good question.
Okay, that's a good question. So Dezenas continues. Justice is therefore grounded in the ethical turn to the other. It is impossible without the one that renders it finding himself in proximity. The judge is not outside the conflict, but the law is in the midst of proximity. Judges, lawyers, and law teachers are always involved and implicated, called upon to respond to the ethical relationship by the other. We must compare and calculate, but we must remain responsible and always return to the surplus of duties over rights. Injustice would be to forget that the law rises on the ground of responsibility for the other, and that ethical proximity and asymmetry overflow the equality of rights. The law can never have the last word.
Ah, okay.
Okay?
Mm-hmm.
And that finishes that section. So, questions, concerns so far? Is all this making sense?
No, that makes sense. Yeah,
Okay.
you unpacking that there helped a lot.
All right. Page 215, the indeterminate judgment. The idea of an indeterminate judgment refers us to two seemingly unrelated traditions, which have contributed to the history of the common law, but have been forgotten in modernity: Aristotelian practical wisdom and casuistry. For Aristotle, practical wisdom is the virtue of praxis. It's an important Greek philosophical term. Practical judgments, unlike theoretical statements, do not deal with essences or with necessary and immutable relations. They have a timely and circumstantial character, and they depend on a full and detailed understanding of the contingencies of the situation. The theoretical sciences examine general principles and the formal connections between phenomena, while practical knowledge deals with the changing and the variable, and with, quote, ultimate particulars, and tries to grasp the situation and its singularity. So, this is the hallmark of what practical knowledge is. It deals with contingencies and connections between phenomena.
Right.
Okay, all circumstantial. That's praxis.
Oh, okay. Okay.
Okay. Casuistry, Casuistry, is a church based form of moral and religious reasoning. Christian casuistry, designed to help priests resolve borderline problems in a principled yet sensitive manner, reached its height of refinement and influence around the 16th and 17th centuries. Casuistry starts from the position of the unique individual in his or her natural and social environment and attempts to describe this singularity in morally relevant terms. It's almost situationalist.
Yeah.
It involves an ordering of cases by paradigm and analogy, appeals to maxims and analysis of circumstances, the qualification of opinions, the accumulation of multiple arguments, and the statement of practical resolutions of particular moral problems in the light of all these conditions. Okay,
Okay.
so that's casuistry, something that's very situational. We're looking at the unique individual and, dare we say, the whole person, instead of here is a rule, that may have a universal aspiration, apply it to this person, we've received a judgment. Okay.
Okay.
That's not casuistry. That's more a modernist approach to what law is.
Okay.
Okay. So, with casuistry, there are certain maxims. There are certain maxims that are involved in here. These maxims were derived from three sources: the Bible, the opinions of the learned who had in the past written about moral problems and whose opinion had come to be recognized as authoritative, and finally, conscience, human conscience.
Okay.
Okay? Continuing, it is evident that one discipline that has taken the injunctions of casuistry seriously for centuries, with only very rare acknowledgments of its close cousin, is the common law. Like
Ah,
casuistry, the common law has the inherent potential to consider sensitively the specifics of the person before it, but the growth of statutory interventions, the introduction of doctrinalism, and of the quote textbook tradition, and the postmodern juridification undermine the casuistic method in law. Okay, so common law still exists, and you can be held responsible for infractions of the common law that maybe you would not be in the regular in the regular law. For example, common law marriage. You don't have to go to a justice of the peace. You definitely don't have to go to a church. You don't have to go to the justice of the peace and get a piece of paper he pronounces you as man and wife,
right.
or husband and husband, whatever floats your boat. You can live together, and under common law, you are married after a certain period of time.
Right.
Because in effect, you're living as spouses under the same roof,
Right.
even though you never went to the justice of the peace to get the piece of paper. Okay, that's a really good example of common law.
Yeah, I've definitely heard of that before.
Yeah. So according to Zenas, this is where casuistry still survived, is in with common law. However, you've had all these other things like doctrinalism, textbook tradition, procedure, even that undermines the casuistic method, which was very much situational, based on maxims. The Bible, is very much Christian oriented, and it's not the whole person. You're not really applying any kind of codes, strictures, things like that.
Right.
Okay, continuing. In recognizing the uniqueness of each case, the common law retains the potential for an ethical application of principles and for the development of a notion of justice that is aware of the requirements of the individual before the court and of the contingency of decision making. The demand that the other is to be heard as a full person, in other words, the demand for ethics, introduces certain minimum communicative and moral requirements for legal procedure as to the type of hearing to be given to the person before the law and the nature of the interpretation and application of the relevant legal rules. The sense of justice returns the law to the other and the good. But we should repeat that law's inescapable commitment to the rule means that injustice is the inescapable condition of all law.
Okay.
Okay? So, what Duzinus is getting at here is that justice leans a little bit more to how casuistry dealt with things.
Right.
Okay, you could even say like a fuller sense of justice. However, because law, definitely contemporary law, sticks to the rules, injustice is an inescapable condition in practicing law and applying the law. Because the
I-
rule is not universal, it cannot apply to everybody.
I'm confused about that.
Yep.
How does that mean that that like that justice is sort of inevitably a part of law?
Injustice.
Oh, injustice.
Injustice, not justice.
Okay. That makes more
Yeah.
sense. I misheard you. Okay.
Yeah. It's injustice. Injustice. What he's getting at is injustice is always done when you're following a rule.
Right. Yeah, that makes sense.
Okay. Next section, postmodern justice. Yay. All right. So page 218, Disney says, we can generalize this reading towards a phenomenology of postmodern judgment. Okay, now we're talking about judgment here. Its operation can be compared with the formal structure of performative speech acts. The performative says and does, saying what it does by saying what it says. For example, I say, I thee wed. The meeting is declared open. War is declared. And so it happens. So the speech act is what you've just said. Performative is you perform a particular action. I
Okay.
thee wed. You have performed a union between a husband and wife or two spouses. The meeting is declared open. You have opened this meeting.
Mm-hmm.
Okay, by your speech you have declared this. This is what the performative speech act is. Similarly, every judgment is implicated with force. The force of the interpretation that turns the singular into an instance of the norm or the particular into a case of the universal, and the physical force that constrains and shapes the body. The rightness of the judgment depends on the institutional felicity of the interpretation of law and in hermeneutical jurisprudence on its accord with moral principles. But its justice can be judged only according to the way it acts. Its action is neither the continuation of the legal interpretation nor its opposite. In many key respects, discourse and force differ.
Okay.
Okay? So, discourse and force, not the same thing.
Of course.
If you are making a pronunciation, that's using discourse. If you are applying force to it, okay? So, just like with the performative speech act, this meeting is declared open. Okay, you have made this speech act. Now, if nobody gets down to business, maybe you could apply force. Hey, come on, guys, come on. Shh, bat him over, knock him over the head with a baseball bat or something like that. Not the same thing.
Of course.
Discourse and force. Okay, continuing. The time of justice differs from the time of interpretation. Interpretation turns to the past or measures up to the future as past and future inhabit the ever present. Interpretation's time is synchronic. The time of action, as
What's
violence or justice, is
what's
diachronic.
synchronic mean? Synchronic?
Synchronic,
Yeah.
synchrony, which is
Oh, okay.
in the same time.
Like synchronized?
Synchronized, yeah.
Okay.
The time of action, as violence or justice, is diachronic. Okay, difference, not at the
Oh,
same time.
okay.
This is the time of the event. It addresses the other here and now in each here and now, and answers or denies the call. This is the pure ethical time, the time of what Levinas calls il y a. That's a French phrase. It is happening.
Oh, okay.
Okay. So, in other words, when you're dealing with interpretation, the same time. But the time of action, whatever its violence or justice, is not happening at the same time.
Mm-hmm.
Addressing the other in the here and now.
Yeah.
Okay. So, continuing. Violence or justice can happen only at the moment of their occurrence. They are the performative aspects of the legal judgment. Nothing that happened earlier, a reading of the law or a commitment to principle, and nothing that anticipates the future, a promise or a vision of a happy community, can account fully for or preempt the uniqueness of the response.
Makes
And as in
sense.
the robbery analogy, the response of the person obligated can only be instant and immediate. Continuing.
Mm-hmm.
In this sense, justice takes again the form of an aporia. So an aporia is a Greek term referring to a sticky point, a sticking point,
Oh, okay.
a sense of a time, not really confusion, but it's like it's not something that can be easily resolved at this point.
Right.
So in this sense, justice takes again the form of an aporia. To be just, you must both be free and follow a rule or a prescription. Okay, let that sink in a minute. To be just, you must both be free and follow a rule or a prescription.
Yeah, that sounds like it meshes well with postmodern ethics, because the idea with rules in postmodern ethics is that there can be rules, but they should be able to be like bent and changed across time depending on the circumstances and whatnot, right?
Or more importantly, is that how can you be free if you're following a rule
Yeah,
or a
exactly.
prescription?
Yeah.
If I tell you, Andrew, you can only have chocolate, vanilla, or strawberry for ice cream, I've imposed a rule or a prescription on you.
Yeah, exactly.
So you can make a choice and you're free to make that choice, but you're constrained in your choice. You could just say, well, I don't want this, I want Rocky Road. Or I don't want
Yeah.
this, I want cookie dough.
Yeah.
Yeah.
exactly.
So that's where the aporia comes in, because to be just, you must both be free and follow a rule or prescription.
Right.
Okay. Can any of these be resolved? A just and a responsible decision must both conserve and destroy, or suspend the law enough to reinvent it and re-justify it in each case. Each case is different and requires a unique interpretation, which no rule can guarantee absolutely. But at the same time, there is no just decision if the judge does not refer to law or rule, if he suspends his decision before the undecidable or leaves aside all rules. This is the reason that we cannot say that a judgment is just.
Ah, okay.
Okay, so kind of makes sense here. Every person is unique, every person is different, because if a person did it wrong, you have to find out the context, you have to find out something of the background, you have to find something out about the motivation, you have to find out maybe the state of mind of what the person did at that time. There's lots of different things that enter into this. So,
Yeah, you have to
but the
find out the relevant context, which is always, it should always be important in legal cases, in my
well,
opinion. But
it should always be that. However,
yeah, it's often not.
yeah, however, you were able to do that under casuistry, but because casuistry kind of wilted away because you don't have the the framework to support it anymore, except in the case of common law, where it still exists in a certain form. The judge has to make a decision. Okay, but the judge can't make a decision unless he follows a rule.
Yeah,
Could be a precedent, could be a legal, statute or whatever it is. So now we're in a bind. The judge makes a judgment, but is it just? Or can we say it's just? I don't think we can say it's just,
right.
because you are applying a rule to this person, and this rule isn't meant to apply to everybody equally,
Yeah, but it often doesn't.
but it often doesn't, right?
Like, like, like drug prosecutions, for example, especially like in the United States, white people and black people use marijuana at roughly the same rates, but black people get arrested in criminal records and imprisoned for it 4 times more than white people.
Right. Or the whole minimum sentencing thing
Yeah,
for drug offenses.
yeah, exactly.
Yeah. That's the judgment, and you can definitely make the argument is that when you're doing that with the minimum sentences, there's a whole lot of injustice that takes place there.
Yeah, that's for sure.
Okay. And continuing, we can conclude that justice has the characteristics of a promissory statement. A promise states now something to be performed in the future. Being just always lies in the future. It is a promise made to the future, a pledge to look into the event and the uniqueness of each situation, and to respond to the absolute unrepeatability of the face that will put a demand on me. This is the face of the other. This promise, like all promises, does not have a present time, a time when you can say, there it is, justice is this or that. Suspended between the law and the good in the face of the other, justice is always still to come or always already performed.
Okay.
The end.
Ah, okay.
Okay.
Cool.
All right. And so we have covered law and justice and postmodernity.
Nice.
Any
Oh,
final
that's good.
questions?
Um, well, maybe you could just sort of sum up what we've covered so far. I think that would be a good idea.
Sure. Okay. So the thing about law, and intuitively, you ask any person who has had some dealings with the law, or maybe who's watched legal TV shows, they're going to say, well, law is about rule, following rules, judgments. They might say something about a judgment, although a judgment is a separate action. It's about following rules. Okay. So that's certainly the case today, following a rule. Way back in the day, you had what was called legal positivism, which is quasi scientific, trying to get to what is law in the abstract sense, defining what that law is, and deriving authority from whatever law is to make judgments. Okay, positivism wilted away, was shown to be increasingly contradictory. Society changed. It was no longer heterogeneous or uniform like it once was. And so what would you do with the law to apply to a heterogeneous, increasingly heterogeneous society and many different voices at work? Well, you still could apply the law because there's something comforting about using the law of following rules that applies to, you try to apply it to everybody at once. And maybe anybody would agree to it. Okay, so if we can't come to an agreement to settle our differences, we can always point to the law. Somebody can say, there you go, here's my judgment. But that's the action of the law. Can we say that justice has been served? Well, maybe in a theoretical sense,